What is a lobby conference in a criminal case? Well, they typically occur in the Superior Court in Massachusetts state courts. You don't see them in district court and you don't see them in federal court. In the Superior Court, before you take a plea, if you're thinking about taking a plea but you're not quite sure, you can sort of test the waters. Instead of just pleading guilty and then making a sentencing argument, you can do a sentencing argument before a plea without doing a plea. So it's a time that both sides articulate their positions. You can submit documents, maybe character letters or other things, and or just argue. And you can argue why you think your side is right. Why should my client get a lesser sentence? Or why the prosecutor thinks you should get a harsher sentence. And then the judge will typically come back and say, okay, if the person pleads out, this is what I will give them. Sometimes they say this is likely what I would give them, but typically you know what the judge is going to do. And then the defendant can decide whether or not that is palatable, is that reasonable, and they can proceed or go to trial. So it's a safer way, because if you plead guilty in the Superior Court in Massachusetts, you could be stuck. You could be stuck with whatever the prosecutor is asking for, because once you do a plea, once you agree to plead guilty, and then you do the arguments, your lawyer can ask for one thing, the prosecutor asks for another. If the judge goes above what the prosecutor is asking for, you can withdraw your plea. It's called a prosecutor capped plea. So you can withdraw the plea and say, thanks, but no thanks, I'm going to go to trial. But that means that if you're pretty far apart and the prosecutor is asking for a lot more time, you could be stuck with that, because anything up to what the prosecutor is asking for, you cannot withdraw your plea because the judge didn't go along with it. Now, the reason these lobby conferences don't happen much in district court is because district court, it's a defense capped plea. Meaning if the defense lawyer asks for probation and prosecutor asks for a year in jail, anything above the defense recommendation, if the judge comes back with, the defendant can go, never mind, thanks a lot, but we're going to go to trial. So it's a little bit different. That's why they primarily happen in the Superior Court. And they typically happen in open court, although there are some courthouses that I've been to the judge's lobby. Barnstable Superior Court, for example, I remember I've been a couple of times into the judge's chambers, where you actually go and sit down and talk to the judge, and the clerk's in there taking notes. But usually it's in an open courtroom. The judge gives the feedback, and then you're more informed, so you can make a better decision about whether to plead or to go to trial.